Hi everyone, today I'll be going over the case Border State Bank of Greenbush versus Bagley Livestock Exchange Inc. Legal terms. Security agreement. A document that provides a lender a security interest in a specified asset or property that is pledged as collateral. The secured property may have superior rights to proceeds from the sale of the collateral. Security interest. An enforceable legal claim or lien on collateral that the borrower provides, allows lender to repossess the collateral and sell it if the loan goes bad. Legal background. Article 9 of the Uniform Commercial Code states that a security interest attaches to collateral and is enforceable against the debtor or third parties when values has been given, the debtor has rights in the collateral or the power to transfer rights, and 3, the debtor has signed a security agreement that contains a description of the collateral. The parties in this case is the plaintiff, Border State Bank, and the defendant, Bagley Livestock Exchange, both in Minnesota. Case facts. On December 1997, Johnson and Anderson agreed to an oral cattle sharing agreement contract, and later a written contract, where they stated that Anderson would take care for cattle owned by Johnson, including offspring sales. On October 1998, about a year later, modifications were made to the contract for Anderson, stating 1. That share percentage would be 40-60 split without Johnson's guaranteed percentage. 2. Johnson would provide feed. 3. Johnson would provide additional pasture. And 4. The agreement would include 500 cattle instead of 151 cattle. However, Johnson denied agreeing to the modification of Johnson having to provide feed, and he also denied that he agreed to change the provision that guaranteed that his percentage of calf crop would be calculated on the initial number of cows, regardless of whether each produced a calf that survived. On March 2000, Anderson negotiated with Border State Bank for roughly $155,528 in loans. To secure the loans, Anderson granted Border State security interest, Anderson's rights, title, and interest in all livestock then owned or thereafter acquired. In December 2000, 289 calves that remained with Anderson were sold at Bagley Livestock Exchange. Bagley knew of Border State's security interest in Anderson's livestock and determined the security interest did not attach to the calves. Case summary. Border State Bank sued Bagley Livestock Exchange and Johnson, contending that they had converted Border State's perfected security interest in the calves sold in December 2000. In a third-party complaint, Johnson sought indemnity from Anderson if Border State was successful on its conversion claim. Anderson served a counterclaim against Johnson asserting breach of contract. The issue? Whether the cattle sharing agreement language is ambiguous and whether the debtor has acquired sufficient rights in the collateral so that the security interest would attach. Case summary. Border State Bank appealed the directed verdict on its conversion claim. Anderson presented evidence on his breach of contract counterclaims, and the jury determined that Johnson breached the contract and directly caused damages to Anderson totaling roughly $92,360. The district court stated that Border State's security interests would have had to grant Anderson an interest equivalent to ownership. As a result, the Court of Appeals determined that the UCC does not require that collateral be owned by the debtor, since the district court did not analyze the modified cattle sharing contract to determine the nature of Anderson's rights, and they had applied a standard of ownership inconsistent with Minnesota law. The appellate court determined that its findings that the security interested did not attach and was influenced by an error of law. The case was remanded to the district court to determine whether Anderson had rights in the calves to which the bank's security interests attached.